All right. Good evening, everyone. I see some new faces tonight, so that's very good. My name is Matt Green. I am president of the Brevard Hand Alex Howard chapter of the Mobile Federalist Society for Law and Public Policy Studies. I'm very excited tonight to be hosting Judge John Denson, circuit judge. He's now retired circuit judge from Lee County, Alabama, and is in private practice. For those of you who are new to some of our events, the Federalist Society is a nonpartisan, conservative, and libertarian organization dedicated to freedom, federalism, and judicial restraint. The Federalist Society seeks to educate the public and the legal community through its programs and publications about how limited constitutional government based on the rule of law can have a positive effect on law and public policy. We have several social media outlets. We have a Facebook page. It's facebook.com/handhoward. And we're also on Twitter, if you want to follow us for future events, at Mobile AL Chapter. So I try to update that on our future speakers and events. Tonight's speaker is Judge John Vernon Denson II. Judge Denson is a graduate of Auburn University, where he received his B.S. degree in 1958. He graduated from the University of Alabama School of Law in 1960, and he also graduated, he did his graduate studies from NYU from 1960 to 61. He also served as a law clerk to U.S. District Judge Frank Johnson Jr. from 1961 to 1962 up in Montgomery, Alabama. He was appointed by Judge Johnson actually later to serve as a part-time U.S. Commissioner and U.S. Magistrate Judge from 1964 to 72. He is a fellow with the Alabama Law Foundation. He is also a member of the Court of the Judiciary, and for you non-lawyers, the Court of the Judiciary oversees the conduct of all judges in the state of Alabama, and he's held that position from 2002 until present. He was elected circuit judge up in Lee County for one term from 2005 to 2010, but he was not eligible to run for a second term due to age limitations in the Alabama Constitution. He is currently practicing with the law firm of Sanford and Denson, LLP, where he specializes in medical malpractice and personal injury. He has probably one of the most outstanding qualities and things in his resume that I most admire, and I'm hoping he'll talk on it at the end of his presentation, was he is one of the founders and vice chairman of the Ludwig von Mises Institute up at Auburn. And that institute promotes free market economics and limited constitutional government. So in many ways, we have very compatible interests. He's also an author. He has authored several books, which he will have for sale after he finishes tonight. A Century of War, Lincoln, Wilson, and Roosevelt, and Reassessing the Presidency, where he dispels the common misconception and mythology of the greatness of Presidents Lincoln, Roosevelt, and Wilson. Yes, yes.
I'm called crazy because
well, you'll enjoy tonight's presentation. He's also a member of the Board of Trustees at Auburn, or was a member of the Board of Auburn Trustees from 1980 to 1999. He will speak to us tonight on free speech in wartime. He'll discuss the very interesting case of a relative of his, Wild Bill Denson, Wild Bill Denson, thank you. The United States of America versus Wild Bill Denson in 1918 Birmingham for violation of the Espionage Act, alleged violation of the Espionage Act, and the legal... Yes. And I'll turn the podium in the back over to him. Thank you. Please join me in welcoming Judge Denson.
Thank you, Matt. It's a real pleasure for me to be here. It's not often you talk about a relative that's been arrested under the Espionage Act, but he's such
used to it though. That phrase can
But when Matt called me about speaking, immediately I wanted to do it when he told me he was with the Federalist Society, because I agree very much with the purpose and the action of the Federalist Society. I taught a course for seniors at Auburn 2 years ago called Creating the American Republic. And let me move this over a little bit here. And in that, I got a textbook and told them about these are seniors in pre-law. And the part that we...
Bailiff?
It's a $50 fine, 5 days in jail.
I took it from the Magna Carta up through the Bill of Rights and showed them the long history of law in English history and the colonial history, how we started out with the Magna Carta taking power away from the king and sovereignty away from the king and to the Parliament in England, and finally in America from the Parliament to the people. And in France, how they kept going toward the centralization of power until you get the two revolutions that are so different between the American and the French revolutions. And one of the quotations that I used from Alexis de Tocqueville, the very astute French observer of America who came here in 1830, I think it was his grandfather represented the king, and when they lost his case, they cut off the king's head and the lawyer's head. So it's right serious punishment for losing a case. But anyway, his family suffered in the French Revolution, so he was very suspicious of democracy and the way it happened in France. But he saw that it worked pretty good over here, he thought. So he came over in 1830 and wrote 2 books about it, and they're very good books if you haven't read them. But one of the quotations in there is he said that when he visited, he said that he considered the American system of federalism to be the most unique and the most important part of the American Constitution. And I agree with that. And then federalism has been under severe attack for many, many years. The whole progressive movement in America was against the Federalist ideas. Even the Federalists at the time of the Constitution were against federalism. It was the anti-Federalists that supported federalism. One of the things I talked about in that course was that the students would ask me, well, is the Constitution dead? And I told them, no, it's just in exile. It can be brought back if we try. And I think that's what the Federalist Society is trying to do. So I fully support you in that. I think the progressive movement reached its zenith or best results for them in 1913 when they created the Federal Reserve System, the Income Tax Amendment 16 and 17 Amendment really destroyed federalism to a great degree, because it was designed in the Constitution that the U.S. Senate would be the body by which they would control and limit the growth of the federal government. And they were supposed to be elected by the state legislature and be subject to the legislature. And I think there's something like 26 states passed laws against Obamacare, but if you had the state legislatures selecting senators, the Senate would not have passed that. So it was a terrible thing for the Federalist movement to pass the 17th Amendment. Let me give you a little bit of background on my cousin, Bill Denson. I've given you a list of books here that are just on the idea of free speech in wartime, which is an interesting subject to me. And I think that you've got the book here, Perilous. Perilous Times. That's the #1 book I put on the list. If you're going to read just one book, that takes you from the first Alien and Sedition Acts in 1798 up to today. It's written by a professor that was head of the Chicago Law School, Jeffrey Stone, and he's written amicus curiae briefs on the subject, and very knowledgeable. But I've got some other books here I'm going to talk about. But the first notice I had while Bill Denson is when I was a freshman in law school, and I was taking a course from a second semester in appellate procedure. And the professor said, we're going to study the appeals of a very unique, brilliant, but very eccentric lawyer by the name of Wild Bill Denson. And so he called me over leaving the classroom, and he said, by the way, are you any kin to Wild Bill Denson? I said, I never heard of him. And so my father was a lawyer. So I went home and I said, Dad, I've taken a course on Wild Bill Denson. Are you kin to us? He said, yeah, but you don't need to know anything about him. So he had a very low opinion. But, in spite of being kin, he's a very unique character and interesting. And it's an interesting case to me, and a lot of things about it. I don't know if Matt passed out this picture or not that appeared in the Birmingham News. This is an artist's drawing of the trial. And I can circulate that, but this shows you he had a sort of a dream team defense. He had 4 Alabama Supreme Court three former Chief Justices of the Alabama Supreme Court and 1 Associate Justice, former Justice of the Supreme Court, representing him. His father-in-law was J.R. Dowdle, who was the former Chief Justice, and then my grandfather was the Associate Justice, and his uncle. And so he had 4 former judges representing him. And this is Wild Bill sitting here. This is my grandfather. This is Judge Tyson, Judge Weakley of Birmingham, Tyson of Montgomery. This is Judge Dowdle from Lafayette, and my grandfather from Opelika. I'll pass that around. You want to take a look at it. Matt did something. I don't know if he sent that out, but it said Denson arrested. I don't know if y'all all got that. When I saw that, I sort of gulped a little bit. Judge Cox will probably see that and wonder what in the world I'm doing down here talking about Wild Bill. But anyway, Bill grew up in a very political family. His father was a congressman from the 7th District, and he died in about 1909. He was my grandfather's oldest brother. He had been a U.S. attorney appointed by Grover Cleveland for both the Northern District and the Middle District. So I think he either moved from Gadsden to Birmingham or Birmingham to Gadsden. He'd been chairman of the Alabama Democratic Party and had been in the state legislature. So Bill grew up in a household where people discussed ideas and politics and stated them. And Bill was, I would say, mercurial, stated his firm opinions about things. My grandfather that represented, he was the chief counsel for him, and that Bill's father had been his mentor in law. He studied in his office. That's the way you did it back then rather than going to law school. And so he felt an obligation, I think, to protect his nephew. Grandfather had been a senator, a state senator. He'd been a circuit judge and an Alabama Supreme Court judge. And he had been the chairman of the Democrat Party that went to St. Louis in 1916 to renominate Woodrow Wilson on the platform that he kept us out of the war. So I think he was somewhat sympathetic to Wild Bill's objections to Wilson. The newspaper had a lot to say about the fact that all these judges were representing Wild Bill. And it was sort of a circus-like trial, and I'll tell you a little bit about it. But to get to the Espionage Act, which is now in the news a lot because of Snowden, really had its genesis in the Spanish-American War. And that gave rise to it, but it wasn't passed until World War I. So let me give you a little bit of background on the Spanish-American War. Of course, it was a very popular war. It only lasted for 4 months, and it was supported generally by the people because the purpose was said to be that they were just going to free the Cubans from Spanish rule. So we were setting these people free that lived next door to us. And so it was very popular. But what they didn't know was that McKinley had other ideas. He was in support of what they call the large policy of the Republicans, and he wanted colonies. He wanted a big, strong federal government. He wanted to do away with federalism. So he had told Teddy Roosevelt, who was the Assistant Secretary of Navy, that we're going to have a war, and when I want you to take a large fleet and send it to Hong Kong and keep them there until we get waterclad, and then go to Manila and sink the Spanish Navy. So Teddy Roosevelt gave the command to Commodore Dewey, and he sailed off to Hong Kong. And when war was declared, Dewey notified this man named Aguinaldo, who was a rebel that was trying to free Cuba from Spain. And Dewey was under the mistaken impression we were trying to free the Filipinos. But that's not what McKinley wanted. So they came in. It was a very short battle. The first shots fired in the Spanish-American War were 2 weeks before any shots were fired in Cuba, and they were fired in the Philippines. So he easily sank the Spanish Navy. And so when McKinley heard that he had Aguinaldo helping him, he put some forces together. Excuse me. And they had the Treaty of Paris in, let's see, it's 1898, I think, 1898. And in that, they granted the Philippines to the Americans, along with Guam and Puerto Rico. And sent a massive army to the Philippines because Aguinaldo started an insurrection. So the war went on for 3 years. There were 5,000 American soldiers killed, 20,000 Filipino soldiers killed, and 200,000 civilians. It was a massive war, and it's not really talked about much in your history books. It's sort of an embarrassment like the Opium War to the British, where they invaded China to make them accept the sale of opium. But this protest group started up, and they were called the Anti-Imperialist League. And there's a book about them, 12 Against Empire, Anti-Imperialist. There were 50,000 members, 500,000 contributors, and it contained membership included former presidents Grover Cleveland and Harrison. It had Mark Twain. Mark Twain had supported the Spanish-American War in Cuba. But when he found out we were going to get colonies in the Philippines, he said, you can't have a republic in America and an empire in Asia. The republic won't last if you go into empire. These were people who believed in Adam Smith. They believed in free market. Adam Smith had come out against the idea of having colonies. He said that capitalism does not need colonies. And so they were warning that we will lose our republic if we start trying to copy the Europeans and go into having colonies. And the one man that put up the biggest fight is the one that caused the Espionage Act. His name was Edward Atkinson. He was a Boston merchant. And he started printing up these pamphlets. And he sent them out to every elected official. He sent them all over Washington. He wrote letters. He got the names and addresses of people in the Army. He wrote them letters. He told them to commit mutiny, put down your weapons, don't shoot any Filipinos. He was a one-man band that was just going everywhere, and nobody knew what to do about it. Some people wanted to charge him with treason. They intercepted most of the mail in San Francisco that was going to the Philippines. But it was this massive protest where he was trying to interfere with what the war was doing by actually telling people not to join, not to re-enlist, and so forth. So when World War I came, they passed the Espionage Act, and I'll get into the timing, which is important to the trial. But talk about World War I, which is the war that Wild Bill was protesting. I'll talk a little bit about the sinking of the Lusitania. This is a book you didn't read in history called The Lusitania by Colin Simpson. He tells the story that it was a ship that was owned and built by the Cunard ship lines, but it also was partially financed and designed by the British government. And in the design, they had secretly put weapons underneath the deck so they could be raised and used in wartime. And they built secret compartments that could hold ammunition and all kind of war materials. And they had the right to take over the ship in time of war. So the war broke out and the British took over. And Churchill was pretty much in charge of running the Cunard line and the Lusitania. So the Lusitania was at New York getting ready to sail to Liverpool. And the German embassy notified William Jennings Bryan, who was the Secretary of State and the only one in the Wilson administration that was against getting into the war. And they told him that they had proof, and you could go down to pier number 54 and see the British loading all these weapons and arms and ammunition in the liner. And that made it a proper target for the submarines to hit. That removed it from being just a passenger ship. And so they begged William Jennings Bryan to go to Wilson and have him warn the Americans not to sail on the Lusitania, and he refused to do it. So the embassy then asked if they could run some ads in the paper warning Americans not to sail on the Lusitania, and it has those the warnings in the book that they ran in New York papers. This all occurred 4 days before the ship sailed. So as it approached Liverpool, it was the fastest ship around, a hard target for the submarines. And they told it to slow down. They removed the destroyer called the Juno from protecting it. And there was a German sub there that they knew, and it fired one torpedo. And there was another second explosion, much greater, when the ammunition blew up and the thing sank. And 1,200 men, women, and children died, along with 124 Americans. So it became the emotional thing about the people thought that the submarines were illegal and unlawful and so forth. But it was clear that under the facts of the case that the Germans could legally fire on the Lusitania because it was carrying what they call contraband. So there were movements in Congress. Two resolutions were offered, one, the McLemore resolution in the House and the Gore resolution in the Senate, trying to require that the president warn people not to sail on belligerent ships, like the British or German ships, and not to go into the war zone, and not to let the deaths of these people that insisted on doing that be the cause of war. Both those resolutions were debated and tabled. So they did not pass. Later on, Senator La Follette, who was one of the 6 senators that voted against the war, actually went public with the statements that Wilson had 4 days warning and was asked by the Secretary of State to give a warning to people not to sail and refused to do it. So this big brouhaha occurred in the U.S. Senate where they tried to remove La Follette for saying that. And then they found out that maybe there was some truth to it, so it sort of died out. So that gives you sort of the background of the Espionage Act and World War I. What I know about the trial, and Matt has done some more research and found some things that I didn't know, but I got somebody to go to Birmingham and go through the archives of the Birmingham News for the trial, which is in July of 1918. This is from the Birmingham News, July 25. It says, 3 former Chief Justices of the Alabama Supreme Court and 1 former Associate Justice of that court are defending William A. Denson in the United States Court here on the charge of disloyal utterances tending to retard the draft brought by federal officials. They're Judge J.R. Tyson of Montgomery, Judge J.R. Dowdle of Lafayette, Judge S.D. Weakley of Birmingham, and Judge N.D. Denson of Opelika. The case is being prosecuted by Mr. Robert Bell, United States Attorney for the Northern District. Now, this is amazing to me. It says many lawyers were present. Inside the court rail, opposite the jury box, and Birmingham's whole outlay of lawyers seemed to be present. They were crowded on desks and tables and radiators, filing cabinets and windows, every place that offered room for them to sit through the trial. Listen to this. Many of them were left only standing room, and they stood up against the bench where the federal judge, W.I. Grubb, was presiding. I mean, can you imagine? Imagine the trial. And these were probably enemies of Bill because he probably alienated a lot of people. He probably, they probably wanted to see him get hanged or something. But I mean, can you imagine a trial like that with the people that had to open the doors and they were there every minute? And I don't know if they kept calm and were cheering or booing or what, but it seemed to be an odd way to conduct the trial. But anyway, it goes into another account. Says Judge Denson gave the opening argument in the trial by interpreting the statute and its terms in the strictest meaning of the words, reading the section of the Espionage Act which his client and his nephew was charged with violating. And I think it was amended several times, but I think this is the way it read on this particular time. Whenever anyone shall willfully make or convey false reports or false statements with intent to interfere with the operation or success of the military or naval forces, or shall willfully cause or attempt to cause insubordination, disloyalty, mutiny, or refusal of duty in the military or naval forces of the United States, he shall be punished by a fine of not more than $10,000 and imprisonment for not more than 20 years or both. It's a pretty severe penalty, and you can be guilty if you're just attempting to do it. So that's exactly what Mr. Atkinson had done during the Philippine insurrection or Spanish-American War. So they figured that if there's going to be opposition to this war, we'll need this act. Then it goes on to say that Judge Denson then argued that Sid filed a Murrah's, arguing that certain charges should be removed from the case, and cited a Montana case. And I did a little research, and I think this is the case he cited. Vess Hall, a young man in Montana in a small isolated village of 60 people, had said that he would not go to war, that Germany would win, that President Wilson was a crook. The war was being fought for the benefit of Wall Street millionaires. Hall was acquitted in the district court on the grounds that his statements could not possibly have interfered with the success of the Army or Navy as defined in the Espionage Act. The judge said it was a mistake to assume that anyone making slanderous or disloyal statements could be convicted under the 1917 law. In effect, he held that there must be some relationship between the act and the results of the act. The Espionage Act, in other words, was not one for unlimited suppression of free speech. So I think that's the case that he cited in defense of Wild Bill. Now, it's important to keep in mind in this trial the dates that things occurred, because the declaration of war was April 6th of 1917, right after Wilson took office for his second term. Then in May, the next month, the Selective Service Act was passed. And then in the next month, in June, the Espionage Act was passed. So you got the war in April, draft in May, and the Espionage Act in June. Now, 1 year later, in July of 1918, the Sedition Act was passed. So the trial is occurring in July of 1918, but he's indicted under the Espionage Act for statements made in April 1918 before the Sedition Act was passed. And when you get into his speech, he could absolutely be guilty of sedition under that act. But the question to get before the jury was that you've got to distinguish. He's just charged with the Espionage Act and not sedition. So that was the main thrust of the cross-examination and arguments before. And the judge then, in his charge, narrowed it down like this. Charged that this is what the newspaper says, that the defendant, to convict the defendant must have willfully and knowingly caused mutiny, insubordination, or the refusal of duty among the military or naval forces, or he attempted to cause these things, which clearly Atkinson had done in the Spanish-American War. Now, The results under the Espionage Act were not very good for Wilson. He was very much upset that there were not more people convicted. There were about 2,000 trials at the time the Sedition Act was passed, and about a 50% conviction rate. So about 1,000 convicted, 1,000 acquitted. So Wilson thought they needed the Sedition Act. And one of the big things that was occurring was that there were some people, the whole socialist movement was against all war. They said that capitalism caused war and the workers should all lay down their arms and not participate in any war. So a lot of the socialists were convicted under the Espionage Act and the Sedition Act. But one socialist, Eugene Debs, had run for president twice before World War I, and he baited the American government to arrest him. And so he told them he was going to make a speech in Canton, Ohio in June of 1918, and there were people in jail that had done a lot less than he did, and he ought to be in jail, so they ought to come and arrest him during his speech, and they did. And so that trial didn't take place till September. But you've got all this publicity going on about the sedition of, the Espionage Act and Debs in June of 1918. And then you got Wild Bill's trial in July. So it's right in the heat of the war. So it was a very bad time to be going to trial under those circumstances. The Birmingham paper summarized the testimony of 22 witnesses that testified against him, and he was the only witness in his own defense. Apparently, the statement that got him indicted at the beginning was made at a restaurant in downtown Birmingham with two other lawyers present. And it's important throughout the whole trial he made no public speeches. These are all private conversations he had with individuals. And he published nothing. He just made these statements to people. The subject came up that Congressman Huddleston from Birmingham had voted against the draft, which had passed in May of 1917. And this conversation is taking place in April of 1918. And Bill came to the defense of Congressman Huddleston, and he said he thought the draft was unconstitutional. This was before the Supreme Court had ruled. And a person in the conversation stated to him that anyone who defended Congressman Huddleston ought to be arrested. And Bill said that he had no fear of saying something like that because you have a constitutional right to criticize public officials. Bill was quoted as saying, quote, "I might go out and criticize the president himself and say he's a traitor, ought to be hung, and the law would protect me, and no one could touch me for saying that." Little did he know. That apparently was taken to the U.S. Attorney, and that's when they started the process of getting him indicted. Then Mr. Scribbler testified that Bill stated, "To hell with the president. He should be hung from a lamppost." In another private conversation with Mr. M.P. Smith, he quoted Bill as saying, "The only reason the U.S. entered the war was to get back money loaned to the Allies." Another witness, Jack Bell, said he heard Denson state in April 1918 privately to him, quote, "The U.S. had no business in this war, and if the people had stayed off the ships, we would not be in the war." Another witness stated that Bill said to him privately, "I would support the government if it was fighting for the right cause, but the war is not being fought for the right cause by America." Several other witnesses said that Bill stated that Wilson was elected on a peace platform, and he turned a traitor. As soon as he was elected, he ought to be hung, and I, for one, would be glad to see it. Another witness said, Bill doesn't hold back much. I mean, he's pretty explicit. And that's part of my grandfather's argument, is that Bill's a little bit pugnacious. Anyway, another witness said that they were discussing the McLemore resolution, and Congress had considered that they should warn Americans to stay off the ship. And Bill stated he supported that, even though Wilson opposed it. Senator Gore had also offered one. That wasn't part of the testimony against him. Now, this is interesting to me. About 4 people came to him for legal advice. And it would be obvious to me these were people sent by the U.S. Attorney to entrap him. Because immediately when they went to him and talked to him, they went to the U.S. Attorney and told him what was said. But they went to him and asked him, should I try to avoid the draft? And he said no. Or should I fill out these forms and not answer them truthfully? No. Do everything. Bill, I'm sure, knew that he was trying to be entrapped, so he didn't let his guard down. And one said that he would had no objection to defending America if America had been attacked, but he didn't think that the Constitution required him to go to France and fight their war. And Bill advised him to fill out the forms honestly and abide by the law. So obviously they didn't entrap him with those witnesses. Now my favorite part of the case is when he took the stand. And this must have been a nightmare to represent Bill. Because I'm sure he was a very, very successful lawyer. He had sued he was a main plaintiff's lawyer, sued a lot of corporations and had a lot of enemies in the establishment. And so he was probably very hard to coach from a lawyer's standpoint. Maybe they didn't even try, but anyway. The U.S. attorney put him on his cross-examination, and he asked him if he had made any statements in April 1918 critical of the president and the war. And Bill stated he had no criticism of the government, and certainly no criticism of any soldiers. He said his own brother was a colonel in the army, and his first cousin, John Denson, who's my father, who had the very low opinion of him, was already in France getting ready to go into the trenches. So he would say nothing against that would hurt the military or his kin who were in the military fighting in the war. But he admitted that he criticized the president because he was elected on a peace platform under the promise he would keep America out of the war. You know, Bill is not just responding yes and no. He's stating whole paragraphs. He stated that Wilson should have kept us out of the war, and he could have kept us out with his promise, but he did not, as he had promised, but did not. He stated a man elected on a peace platform and then immediately after election asked Congress for a declaration of war was a traitor. He admitted that he criticized Wilson for doing this. He stated he had a constitutional right to criticize the president at the time he stated it. He stated, I was not critical of the government or the Congress or the military, just the president. Now, here's the zinger. This is hard to imagine he did this, but he said, I still think all these things right now, but I wouldn't say them since they passed the Sedition Act. You thought or hope of your client, the jury gets the idea, he's changed now, he's okay now. He said, no, I still think all those things, now I just don't say them anymore. Well, the Birmingham Ledger reported on Saturday about the trial and the verdict and the final arguments, and the Judge Tyson, Judge Weakley, and my grandfather all gave closing arguments. Judge Weakley spoke on behalf of the defendant, pleading that he was innocent of any intentional design to thwart the military or naval forces and any conduct in the war. He cannot convict a man of a crime merely for expressing his opinion. He said you must show that in making the statements charged, the defendant made them with the intention in his heart of causing or attempting to cause mutiny, insubordination, or disloyalty in the armed forces. The government has not offered to prove an instance where anyone was even influenced at all by the statements that he made. And certainly no member of the armed forces has failed to do his duty on account of anything that he said. Judge Denson's argument referred to the family connection with his defendant's father, Congressman Denson, and he's pointed out that if all the statements made by the defendant were private conversations and not public speeches, it would be a disgrace under the law for the fundamental principles of our democratic government if they would convict the defendant merely on public opinion without going into the nature and circumstances of the statements. And you must show that he had an evil intent in his heart when he said it. And he said, he talked at length about the nature of the defendant's temperament, stating that he was an impulsive young man given to decided opinions on questions of the day and impetuously advocating those opinions when forced to do so in an argument. That would be an understatement. Then the prosecution, Robert Bell, got up and argued that paid the highest respect to the former judges that were representing Bill, and stated the government had no ill feeling toward Bill, and that the government was seeking to do its duty towards the people. And in a great crisis of war. He stated that the defendant was not making statements in a jocular tone or voice, but in a serious manner, and that would be true. And he said, the gentlemen of the jury, I was amazed to hear the defendant repeat some of those statements on the stand today. I'll bet. Bell continued, the country at war needs the loyalty of all the citizens, and a man against the president is most certainly against the government. Assistant U.S. Attorney Ralph Quinn, in his closing argument, dwelt on the fact that it was not the president, but it was Congress that declared war. He stated the war was caused by violations of international law perpetrated by the government and its people, by the German government, leading to the declaration of war. Now here's a point I want to emphasize. He stated that there's a difference in the interpretation of free speech in time of war and in time of peace. He stated that the authority and esteem vested in the president as commander-in-chief of the army must be protected during a time of war. The jury went out on Friday and spent the night in the hotel, came back at noon on Saturday and found Bill not guilty. I want to close with what I think is one of the most important U.S. Supreme Court cases that arose in 1866. Not many history books talk about this, but during the election of Lincoln in 1864, 30,000 people were arrested for making statements against the war. And they were arrested without warrants and tried in military courts without habeas corpus, without counsel. And then some were sentenced to death. And one Congressman Van Landingham was banned from the United States. Marshall, and what they said that what was wrong with this is that all these people were in the North. They were in places where the courts were in place. There were courts available to try these people. And you can't have martial law and take over and try these people when the courts are available. So Mr. Milligan was confined in his bed. He was a Democratic politician. He had been arrested in 1864 in his sick bed at home in Huntington, Indiana, for involvement with the Sons of Liberty, a disloyal organization. He was tried in Indianapolis by a military commission consisting of 11 Army colonels and one general and sentenced to hang. In 1866, Milligan's case reached the U.S. Supreme Court, which scolded the Lincoln administration in no uncertain terms when it declared Milligan's military trial illegal. And here's what the court held. The Constitution of the United States is law for rulers and people equally in war and in peace, and covers them with the shield of its protection and against all causes of men at all times and under all circumstances. No doctrine involving more pernicious consequences was ever invented by the wit of man that any of the provisions can be suspended during any of the great exigencies of government. Such doctrine leads directly to despotism. So I think that's one of the great decisions of the Supreme Court, that the Constitution should not be interpreted differently. It applies at all times, and you can't have a living Constitution that goes one way at one time and one way another. So anyway, this is, I guess, you shouldn't talk about a relative that was tried, but at least he was acquitted, and it does tell you a little bit about the Espionage Act, which is now in place. In the Sedition Act expired in 1920, or was repealed. And one thing, thinking about federalism and so forth, the first Sedition Act was 1898, passed by the very people that formed the Constitution under the John Adams administration. And it made it illegal to criticize the president, the Congress, either House of Congress, but you could say anything you wanted to against Vice President Jefferson. And it was set to expire at the end of John Adams' term. So they were suspicious that the Anti-Federalists and Jefferson were consorting with the French and going to have a war, so they passed that first Sedition Act. So I think it shows something about the nature of the conflict even at the time of the Constitution, that there were people, the Federalists at that time, were not for federalism. They were for a national government, a strong central government, and it was the anti-federalists who supported federalism and tried to limit the power of government. So I want to congratulate all of you for what you're doing with the Federalist Society, and thank you very much for inviting me. I'll be glad to stay and talk. I know some of you want to go.